Secure Transaction students, good to see you again. I'm coming at you through the wonders of internet video, YouTube, to cover the final assignment for this week, which encompasses just two problems, problems 66 and 67, in which we continue to explore the concept of priority, and we'll also continue to talk about future advances. So let's just jump into problem 66 and take it from there. So I'll read the problem here. Assume in the last problem, okay, and the last problem was problem 65, and so let's start there. First National Bank took a perfected security interest in inventory of J. East River's clothing store, and the security agreement provided the inventory would secure not only the current loan but all future advances of whatever kind. This critical feature of a floating lien, that it covers not only the initial loan that's given but any future obligations, any future loans. So there was a security agreement covering inventory on all future advances, and then 6 months later First National loaned East River an additional $10,000 and had him sign a new promissory note for that amount. Does the existing filed financing statement security agreement need to be altered in any way? And the answer to that was no, because as long as you have that future advances language in the security agreement, and then you have a financing statement covering inventory, you're good. You can just keep loaning money, and whatever you loan will be secured on the inventory. Okay, and now move into problem 66. We assume the facts of 65, and then it goes on that after First National made East River the first loan and filed its financing statement, East River then borrowed more money from Second State Bank. So we have a new lender in the picture, and he's using the same inventory as collateral. Okay, and this lender also filed a financing statement in the correct place. Very good. So we have two banks, two secured parties, two perfected secured parties. They both filed a financing statement and did a security agreement, gave value. But then East River, the debtor, paid off the loan to First National completely, but the bank never filed a termination statement. So its financing statement, continued to be on the rolls in the Secretary of State's office. And then a month later, after First National was paid off entirely, First National loaned East River more money, and the parties signed a new security agreement, but no new financing statement was filed. Now, First National's attorney reasoned that the earlier financing statement would protect the later loan's priority, even though this loan was not contemplated when the first financing statement was filed. Is this right? Well, Second State argues from the other side. Second State would prefer that the court find that the first financing statement was spent when the underlying debt was paid off and could not be used to give priority to a later uncontemplated loan. Well, what is the answer? And the answer is that that first financing statement is perfectly valid and sufficient to perfect the security interest in that second loan. As long as the financing statement has the name of the debtor, the name of the secured party, and describes the collateral, it's going to be sufficient to perfect the security interest in whatever securing whatever loan at any time was made. As long as it's on the books, it's sufficient. So it doesn't matter that you filed a financing statement to secure one loan without even thinking that there would be a second loan, and then later on, as here, decide that you're going to extend another loan. That first financing statement, even though it was filed in connection with a totally different transaction, it's still sufficient because it has the name of the debtor, name of the secured party, and a proper description of the collateral. Okay, then it goes on. Often a security agreement will have in its clause stating that the collateral protects not only this loan but all future advances as well. And that's true. And it refers you to 9204, which is the future advances clause, this important component of a floating lien. And I'll just read it. 9204C, a security agreement may provide that collateral secures, or that accounts, chattel paper, payment intangibles, or promissory notes are sold in connection with, future advances or other value, whether or not the advances or value are given pursuant to commitment. To really hone in on the relevant language there, I'll reread it. A security agreement may provide that collateral secures future advances. That's the important concept. So a security agreement can say that the collateral secures the payment of the initial $10,000 loan plus all future advances. More likely, this is more typical language, security agreement will say, and I'm going to bring a security agreement soon so we can look at it, but a security agreement is more likely to say that the debtor grants the secured party a security interest in its collateral, however you want to describe it, in order to secure all existing obligations and all future obligations, however they might accrue and of whatever type they are. Have some kind of language like that. And it's perfectly valid under 9204C, and all obligations, whenever they arise, will be secured by the collateral that is described. So future advances, perfectly permissible. You want to have that future advances language. If you don't have it, if you just have language that says the collateral secures the $10,000 loan issued on January 1st, then that's the only obligation that is going to be secured. If the bank later on extends a loan, in June, another $10,000 loan, then it's not going to be secured under that security agreement. So, but as long as you have expansive language saying that all existing and future obligations are secured, then you're good. Then you can loan tens of millions, hundreds of millions of dollars, and it's all going to be secured. And that's the point of this final question. I sort of jumped the gun. The final question is, if such a future advances clause had not been in the original security agreement that East River signed with First National, does that affect the answer at all? And yes, that can get you in serious trouble if you don't have a future advances clause. Then the secured obligation could be limited to the obligation that's described in the agreement. Okay, that's problem 66. Problem 67. Philip Philately pledged his valuable stamp collection to the Collectors National Bank in return for a loan. And then he gave CNB, Collectors National Bank, an oral security interest in the collateral, and no financing statement was signed. So he just gave it to them and said, here, you can hold this as collateral to secure the loan, and gave it to them. And the bank put the stamp collection in its vault. Okay, took possession of the stamp collection. Good, and the stamp collection is just goods. So what we have here is a possessory security interest, a security interest in the stamp collection perfected by possession. Perfectly fine. But then Philately later borrowed money from his father, Filbert, and gave him a signed security agreement in the stamp collection. And then the father filed a financing statement in the proper place. Answer these questions. Okay, well here we have again a perfected security interest. The bank has a perfected security interest in the stamp collection by possession. Father by filing a financing statement. They're both perfected secured parties. What's important to note here as well is that the security agreement for the bank was oral. And that's fine. You can have an oral security agreement if you take a possessory security interest. If you are perfecting by filing a financing statement, then you need an authenticated security agreement, which is what the father had. So they both attached, both had proper security agreements, and then they both perfected, one by possession, one by financing statement. Here's question A. Who has priority between CNB and the father? And this is a classic 9-322 priority rule, first to file or perfect. The question is, and that's the priority rule. This is a core priority rule between perfected secured parties. If you have two perfected secured parties, who wins? The one who's first to file or to perfect. not necessarily the first to file, not necessarily the first to perfect, but whoever got to either of those things first. And here what we have is priority for CNB, for Collectors National Bank, because they were the first to perfect. The father perfected later when he filed, and filed later as well. So Collectors Bank wins because they were the first to perfect in this case. If the father had filed first, then the father would have won, whether or not the father was the first to perfect. I hope you're comfortable with that, with the nuances of that statement. And because the father could have been the first to file, but perfected later if, for example, the father had not given a loan or signed a security agreement until after possession was taken, because that only then would attachment have taken place, and perfection only takes place when attachment takes place and another step is taken. Filing a financing statement is not necessarily perfection. Right? If you just file a financing statement, you haven't perfected because you haven't attached yet. But when you do attach and later on the debtor defaults, the party that was first to file will win, because the rule is first to file or to perfect. But in this case, CNB wins because it was first to perfect by possession before the financing statement was filed. Okay, now we can talk about this in class if you have any question. This might be a question that you all want to raise in class again and have me go through it. This is just the core priority rule of Article 9, so you've got to absolutely 100% be comfortable with it. B. If Philip goes to the bank and takes the collection home so he can add new stamps, but then does not return it, does the answer change, this priority answer? At common law, the pledgee could return the collateral to the pledger for a temporary and limited purpose without losing perfection. Has this doctrine survived the enactment of the code? And the answer is it does change the answer. If as soon as the bank gives up possession, it loses perfection. And so if the bank took possession and was perfected, and then the father filed a financing statement and was perfected, and then the bank gives up possession, and then there's a default, bank loses. The bank lost perfection. And then you have the question between a perfected secured party and an unperfected secured party, and under 9322, the perfected secured party wins, always defeats the unperfected secured party. So, and then it cites here to 9312F, but 9312F talks about a bailee. Right? Talks about which is a third party that's in possession of the goods. Here we're dealing with a secured party in possession who gives up possession. So 9312F does not apply. If you look at 312F, it talks about goods in possession of a bailee who gives them up temporarily for storing, shipping, manufacturing, processing, etc. And then if it's a bailee that gives up, and we had a problem that dealt with this, if we have a bailee that gives up possession so that the debtor can do something to perform maintenance or something on the goods, that's okay. You maintain possession for 20 days. But if it's a secured party, as it is here, as soon as you give up possession, you've lost perfection. C. If Collectors National Bank makes Philip sign a security agreement and then turns the collection over to him but never files a financing statement, who wins? What should CNB have done? So now we have Collectors National Bank taking possession, perfecting through possession, and then having Philip sign a security agreement, and then they turn over possession to Philip. Who wins? And the answer is that, again, the father is going to win. Again, it doesn't change the answer. As soon as Collectors National Bank turned over possession, it loses its perfection, and then the father wins, because the father is a perfected secured party by filing a financing statement. And then they ask, what should CNB have done? it should have filed a financing statement before turning over possession, and that's the point of this part of the problem, is that if CNB perfects by possession and then has him sign a security agreement, and then if they had filed a financing statement and then turned over possession, then CNB would win. It would have continued to be perfected, because it would have been perfected by possession and then perfected by financing statement, and then when it turned over possession, it would have continued to be perfected by the financing statement, and so it would have had continuous perfection and would have defeated the father. And that refers to 9308C, which talks about continuous perfection. If you were perfected one way and then you perfect another way, you'll be treated as having been perfected as of the date of the first perfection. All right, so here, Collectors National Bank perfected by possession, then filed a financing statement, and then turned over possession to the debtor. When it comes down to we assume that the father filed the financing statement before Collectors Bank filed their financing statement. But then when it comes down to the priority contest, the court will just ask, well, what was the date where Collectors National Bank was first perfected by possession? And that's the date we're going to use for the priority contest. Even though Collectors National Bank filed a financing statement after father didn't matter. As long as they filed a financing statement, while they were in possession, then it will be treated as continuous perfection, and the date for the contest will relate back to when possession was taken. So even though it filed second, it will win the first to file or perfect contest because it was first to perfect. It's just all tricky stuff. I mean, it kind of rolls off the tongue after you've been doing it for 15 years. But think about this, watch the video again, and then if any of you have a question, just say, Professor Sundahl, can we go over problem 67 again? I hope one of you does that. Please, someone do that so I can run through it again and we can all get straight on this. So that's all for this week, and I look forward to seeing you all on Tuesday. We're going to be live in person from here on out, and I'm going to send you an email with Tuesday's assignment, but we're moving on to the next assignment, obviously. We just did finished assignment 7 through 67, so we're moving on to purchase money security interests, problem 70 through 72, 74 through 76, but I'll send you an email about what we should expect to cover on Tuesday, and I look forward to seeing you all then. Ciao.